So let me tell you something about myself and my own background. I did my law studies over 5 years, did the arts law course at the Australian National University, came to Sydney, did the College of Law, and went into legal practice. And for the first 11 or 12 years of my life, I led the life of a litigation solicitor. I worked in different litigation law firms that cut their teeth on and made their daily bread from taking matters to court. So I was a fully fledged litigation lawyer. And my whole persona and all my belief systems as a trained lawyer was, how do we take a client's case that comes in the door and turn it into a winnable case? If we had to use strategies and tactics to do that, that's what we would do. But it was all about satisfying clients' interest by making them the ultimate winner. Now, at the end of that time, I then changed and was admitted to the New South Wales Bar as a barrister and continued on my life as a litigation lawyer. And again, I just want to make it clear here that in this state, as a lawyer, you feel you're doing the right thing in trying to help clients win their cases. And your whole way of looking at a dispute is confined and limited to what do we need to do to shape this case up, to take it into court and win the case for the client. Now, things changed for me in about the year 2000. And that's when I went off and did my Master of Law degrees at the University of Technology, Sydney, UTS. And that introduced me for the very first time to a whole different way of looking at managing and resolving disputes. And essentially, it opened my eyes to the fact that, in all honesty, when people have a dispute, particularly commercial disputes, and that's what we deal with, they're not really interested in these names that we apply to things like, solicitor, barrister, mediator, arbitrator. What they really want is someone who has the skill set to help them properly understand their dispute holistically, so that they don't make what could be one of the worst decisions of their life to rush off to court and then 12 months later, 18 months later, be sitting there thinking, how did I ever get here? I've incurred all these legal expenses now. I've been so distracted from my personal life and my business life, and now I'm facing this trial, this hearing now, to try to become the winner, and my lawyers are now telling me, now that they've seen what the other party's been saying and looked at their evidence and their documents, are saying to me, Chris, Frank, whoever you are, we're not certain now. There's a chance now that you might not win. So we really encourage you now to go to mediation and try to settle this dispute, rather than leaving it up to the judge, because if it goes against you, not only will you not get a cent, but you'll be ordered to pay the other side's costs. When I could understand from your point of view, sitting in your seat, how that must look, and then studying this whole science and this art of what I call the art of early dispute management, the art and science of early dispute resolution, it wasn't hard for me to come to the conclusion that we as lawyers need to put aside that persona and say, really, the skill we need to develop, who we need to be, is a skilled, highly skilled commercial dispute resolver. We need to be experts in resolving disputes outside of litigation. The time has come not just to pay lip service to a responsibility to do this, which in fact, for those of you who don't know, is been said now for the last 10 years. It is part of a lawyer's duty of care to a client to make sure that they are given proper opportunity and afforded proper chance and prospects to resolve their disputes before, you head them into court. But how many people are really doing that? How many are doing it in a genuine, sincere way with due diligence before they pop you into the court system? Not enough. And it's not just me that says that. This is being spoken about now regularly by senior politicians, by attorneys general, that the legal system and those who participate in it must take this duty very seriously. So we do at the Commercial Disputes Management Center. We do take it seriously. And we've set up a whole way to ensure that we can give you this opportunity. And that if you ever do enter the doors of the court or some tribunal, you do so because, and you only do so after you've really made a genuine attempt, a reasonable attempt, properly assisted to resolve that dispute, and all attempts have failed. Well, if that happens, you never lose your right to enter the court system. It's always there waiting for you. The only way that can be taken away from you is by the contracts that you might make with someone else that you go into a commercial deal with. So over the last 30 years, I've been a litigation solicitor. I've been a barrister specializing in litigation, which is the running of the cases in court for my clients. I've been an arbitrator sitting on different panels, court panels, and I've been a mediator. And so over that whole period of time and being able to look at disputes in so many different ways, it's brought me to the point now where I felt compelled to set up the Commercial Dispute Management Center in a particular niche, which is the niche of commercial and business disputes, with the total goal and objective of doing all that we can to help businesses avoid litigation and to help businesses manage and resolve their disputes early, quickly, cost-effectively, and very, very importantly, without damaging important relationships, important commercial relationships. These are the things that we pay attention to. If none of that works, you always have your constitutional right to go to court.